When considering whether or not you have a medical malpractice case, a couple of things you want to first consider is obtaining your medical records if you can, keeping the piece of surgical equipment that might have been removed and putting it together, and then calling a firm that specializes in medical malpractice. What you don't want to do is pick up the phone and call your doctor and sort of open up this can of worms that can't be undone at the end. Certainly, too, sometimes hospitals or physicians will reach out to the patient or the family members of someone that they believe has a medical malpractice case. And you don't want to really engage in those conversations because they're calling for a reason. You really want to reach out to someone who knows and specializes in medical malpractice to see the right steps in the right direction of what is best for your case moving forward. So when thinking about the time frame of when you can sue for medical malpractice, it's really 3 years from the date you knew of negligence or when you should have known. For example, if someone passes away, it's 3 years from the time of death. Whereas if someone finds that a sponge was left in them after a surgery, it's the time that they knew of the sponge being left in and not the day of the surgery. So it's when you knew or really should have known as the patient or the family member or the head of the estate that the negligence occurred. Medical malpractice cases take significantly much longer than other types of cases in your normal personal injury case. Really from start to finish, from the moment the client calls us until the time of resolution, which is either settlement or trial, it can take anywhere from 4 to 6 years. Once the case is filed in a court of law, no matter what state you're in, you're looking at about 3 to 4 years from the time the case is filed until the resolution, and that being a settlement offer or going to trial.